$160 million was what it cost to build the Wellmark building. The building was finished less than a year before the assessment that is at issue. The appraisers for Wellmark would have us believe that the value of the building disintegrated from $160 million down to $68 million in that short period of time. The trial court decided that the value had gone down from $160 million to $78 million in just a few months. That occurred because the appraisers for Wellmark applied a method of appraisal that is becoming more common, and it's frightening. They are simply pretending that the use has changed to a much less valuable use. And in this case, it is quite clear from the record that it is not going to change in use, that it is a building that functions well for what it was built for.
What did the appraisers determine the highest and best use of the building was?
They said...
And is there a difference between the appraisers? Help me out here.
The appraisers for Wellmark said that the highest and best use was a continuation of the property as a office property. And it's hard to dispute that statement. But what they then did was they went to Class B and some Class A and Class B multi-tenant office buildings as their comparables. And they used those buildings.
I thought the court didn't rely on the comparable studies. They relied on the income approach.
The income approach, you're right, they did. That is what the court did.
I guess my first question would be, do you have any problem with them using the income approach rather than the comparable approach?
I do have a problem with them using the income approach in this situation, because the income that they used was the income generated by investor-owned, multi-tenant properties, most of which were much older than the Wellmark property. There were one or two single-tenant buildings amongst the rental comps that they used, but for the most part, they were multi-tenant buildings. There's a couple reasons that's important. Most multi-tenant office buildings don't have cafeterias. They don't have auditoriums. They don't have series of meeting rooms. They don't have the level of finish that you see applied to a home office building. And so by comparing the rents of multi-tenant investor-owned properties like the financial center to the Wellmark property, you're ignoring the value of all of those things. You're just completely discounting it.
The problem I have with this case, I mean, you have a building that was, as you point out, built at great expense to be kind of a show building, a flagship building for Wellmark, and to have lots of amenities for its employees and all of that. And all that is true, and I assume Wellmark was using its policyholders' money and its reserves and its whatever, its capital in the manner it thought advisable. But now, when we value it, we're told as courts, whether it's the trial court or the Court of Appeals or us, we're supposed to give preference to sort of a comparable sales approach, and it's very hard to find comparables for that, isn't it? Isn't that really kind of the problem? And so then you have to use these other methods that are a little harder, right?
I have a two-part answer for that. First, it's impossible if you want to use comparable sales from the Des Moines area. There just aren't any. You can make some huge adjustments to some sales, and you can apply them. You can go to the Midwest or the center of the country from Canada down to the Gulf and pick up some sales there that are a little more comparable. But there's not very many of those.
But if we use, I'm sorry to interrupt, but if we use sort of the sales approach, one of your appraisers is much higher, but one of them is pretty much in line with what the district court did, just a little bit more, and what the Court of Appeals did. Isn't that right?
Yes. Mr. Shaner, using the sales approach, I believe had $83 million. But he also said in testimony that he arrived at that by using the only comps that he could find, and that they were crummy comps. I've never heard an appraiser admit that before, and I thought it was rather candid that he said it. But he did not do a nationwide search. His database was limited to cases that were primarily in the Midwest. Only Mr. Corpax had a nationwide database of sales.
Yeah, I've got some problems with that too, of course. I mean, real estate markets are local in nature. A building in Chicago or New York or Miami will have a different value than a building in Wichita or Des Moines, don't you think?
Yes, but he did not ignore that. He analyzed the different features of those buildings, and he spoke about those on the record and in his in transcript and in his report.
He did, but let me just share kind of a frustration, I guess, is that what we have in the testimony, I think, is looking at sales nationally that are admittedly not terribly comparable, and then we make adjustments of percentages up and down that seem of the most imprecise character, based on, I'll call them guesstimates, and maybe you have a better word for it, and maybe you want to challenge me on calling them guesstimates, but at the end of the day, you start with an unstable figure to begin with, and then you do some unstable adjustments. At the end of the day, I wonder what you have.
I won't deny that this is a tough property to appraise using either the income or the sales approach. I think he's the only one that really tried to find comparable sales. He found 7, I believe, comparable sales that he said were quite similar. Once you compared their pluses and their minuses, they were quite similar. And they didn't need any adjustment.
Well, I'm going to take us to a little different direction here. You know, when we started the conversation, you said that we probably needed to use the income approach, and of course that's what the district court ended up settling on, was the income approach. The Court of Appeals relied upon the income approach to determining these properties as being accurate and valuable. And if I'm looking at the opinion correctly, even from an income approach, all 4 of the appraisers here using the income approach, which everybody appears to agree is the most accurate value, ranges anywhere from 68 to 87 million. And so what do you think this is worth? You're saying that, oh, instead of the 78 that we ultimately agreed on, it ought to be 89, or, you know, we're never going back to 160 million. So what are we supposed to rely upon, or what do you think we should be relying upon to say this is the taxable or the true value of this property?
I did not intend to say that I thought the income approach was the best approach.
But we've just been talking about what a sort of a joke trying to find comparable sales approaches are. And with the adjustments of anywhere from 79 to 179%, but I guess you're not willing to concede that, and that's fine.
Well, Mr. Corpax did not need to make adjustments to his comparable sales. He found 7 that were so similar that he didn't adjust them at all. And he checked them using a different method of determining the accuracy of comparable sales, and he found that those 7 were right on. Mr. Shaner quite explicitly said the cost approach is the best approach. Mr. Jenkins said that when you have a new property and when there are not good sales and when the income approach doesn't work very well, the cost approach is a good approach to use. Now, he made that comment in his appraisal report. And 2 paragraphs later, he said, I'm disregarding the cost approach. I'm going to rely on the income approach and the sales approach.
His cost approach was pretty similar to the income approach. I mean, there was a $3,000 difference.
Yes, because he made it similar. He fudged the number by making sure that his functional obsolescence subtracted the difference between his income approach and the cost approach.
If the building costs $160 million, how does your appraiser, even your high appraiser, end up with $145 on a building that's less than a year old?
Mr. Shaner came to the conclusion of 145 primarily.
149. It's 149.
Primarily using Mr. Shaner used a cost approach, and he did think that there would be some functional obsolescence. He thought that that functional obsolescence existed because perhaps, and perhaps is important here, perhaps it would not be possible to find a single tenant who would rent the entire building. Perhaps one or two floors of the building might need to be segregated out and rented to someone else. And that cost was about, I believe, 20% of the value under the cost approach. After subtracting that amount, he concluded that the cost approach would be 149 million, whatever. I don't recall exactly what the number was. That's not a bad way to do it, except he was being super cautious.
Is that really true? Let me just ask you. This is a very large building for Des Moines, and it's located, of course, in the center of the city. I'm sure Wellmark is happy with this building. But if it chose to attempt to sell the building, what are the prospects really of getting a single buyer to come in and occupy the space? I mean, I think the argument is it's a huge building. Des Moines fortunate to have Wellmark downtown, but if Wellmark were to leave and for whatever reason decide to sell a building, that the likelihood of a single buyer coming in was pretty slim. What's your response?
Well, that's definitely the opinion of Mr. Jenkins and Mr. Franson. However, the assessor, Mr. Rippiger, suggested, well, he didn't suggest, his testimony gave examples of companies that had bought buildings as part of the transaction of buying the company. Nationwide Insurance purchased the Allied buildings. There were two of them at the time. Aviva purchased Ameris Insurance.
What was the square footage of those buildings? So, I mean, this is 600,000 square feet?
It was not 600,000 square feet, but Aviva built a building that is almost that large when it moved out to West Des Moines. It had people scattered out in some other rental properties. Marsh Reinsurance purchased KVI. That was a huge building. Wells Fargo bought Norwest and all its buildings. ING purchased Equitable of Iowa, including the several Equitable buildings. Any purchaser of the property would be looking to buy a property that was located anywhere in the country. And that's one of the reasons that Mr. Korpax's value is important. Because if some company was wanting to buy one of these buildings, Corpax's data indicated that for the same building, they'd pay $150 million.
Thank you, Counsel. Ms. Tharnish?
Thank you, Your Honor. May it please the court. What the county wants this court to do is to buy the appraisal of Mr. Corpax. That's what they urged the trial court to do, and the trial court wouldn't do it. That's what they urged the Court of Appeals to do, and the Court of Appeals wouldn't do it. And that's really essentially the bottom line of their argument today, is that Mr. Corpax got it right, and the other three appraisers, including an appraiser that the county hired and whose evidence and whose appraisal the county submitted, got it wrong, as did the assessor in this case. And the court should reject that attempt by the county, because Mr. Corpax did not get it right. As you've noted through some of the questioning, Mr. Corpax did not look at a single property in Des Moines. He did not look at a single property in Polk County. He did not look at a single property in the state of Iowa. He did not look at a single property that was the exchange between a home office owner and another single user. Every single comparable sale, or so-called comparable sale that he used, was a lease transaction. It wasn't a fee simple. He didn't value the fee simple of this property.
Didn't he use a form of a cost approach, though?
He didn't, no, not Mr. Corpax. Mr. Corpax relied primarily on the sales comparable approach. He did do all three approaches to value, but he relied primarily on the sales comparable approach. But he used properties in the Washington, D.C. area that were leased to governmental entities. He used properties in San Jose, California. He was using properties that were not similar. And to compound the issues, while Mr. Hibbard said that he didn't find the need to adjust these properties, in fact, Mr. Corpax did not do a numeric adjustment, as all three other appraisers did in this case. He just did a inferior, superior, similar on each of those for the different factors. And so that makes it very difficult for anyone reading the appraisal to determine how much did you adjust because of that factor. And in fact, far from him not adjusting the most similar, there was one of the properties that he considered similar that of the 7 factors he looked at, 5 of them were something other than similar. They were either inferior or superior.
There is, let me tell you where I'm coming from. There is this element of sticker shock that a building that Wellmark just paid $160 million to build, it now is saying, well, we paid $160 million for something that's really only worth 78, and that's jarring a bit. And it seems to me, just looking at it, that all of these appraisers have lots of ways you can pick at their reports, and what's a judge to do, I guess, is my question.
All right, so I'd like to address what I think is really 2 questions. The first, what's a judge to do, is you do exactly what Judge McClellan did, and that was to, number 1, see all of these experts testify. He saw them give their direct testimony. He saw them be cross-examined. He carefully reviewed their reports, and he didn't just use the values that our appraisers came to. He made adjustments, and in fact, I think there's a pretty good argument that he took Mr. Shaner's valuation on either the sales comparable approach or the income approach and adjusted that to take into account the fact that Mr. Shaner had failed to recognize the fact that the second floor of this property was essentially was unused, and so all of the other appraisers made an adjustment for that and applied that adjustment to what Mr. Shaner had done. So I think what the judge is supposed to do in this case is exactly what this trial court judge did, and I think you need to give deference to that because he's the person who heard the witnesses and carefully examined it. But beyond that, to the sticker shock question, It's undisputed in this case by everyone that the cost of construction doesn't reflect the market value of the property as market value is defined under Iowa law. The assessor agreed with that. Think about that. The assessor valued this property at $99 million. The assessor had all the information about the cost. So the assessor recognized that the cost would not be a fair reflection of the assessed value. And in fact, Mr. Rippiger specifically testified that of course the value of the property isn't its cost. A willing buyer would not be willing to pay what Wellmark put into the property. And that's the test under Iowa law. What would a willing buyer pay a willing seller, both having knowledge of it? So I don't think it's a question of, yes, the cost into this is larger than the assessed value, because everybody agrees to that. The question is, what's the appropriate amount of obsolescence? Sorry.
I've tried to look through these appraisals and the record. Is there anywhere in this record that shows what Wellmark is carrying this building as for asset purposes? Did anybody, I couldn't find it in the appraisal reports, and I didn't see anybody go down to the insurance commissioner and introduce that. And is there any record in here at all what they're doing as for the reserves and for, I don't even know if they're using for reserves, but carrying it as an asset?
Right. I don't recall any testimony in that regard in the record.
You have to file an annual statement with the department, with the insurance division, that it was sort of an accounting statement. It's kind of like an SEC disclosure. Is that, and that's not part of the record, is it?
That's not part of the record, Your Honor, and I'm sorry we've gone beyond my knowledge of what Wellmark.
Well, you're stretching mine.
I know it wasn't part of the record. I just wanted to know, normally when you do these things, the appraisers include in their report what the owner is carrying the building as. And I didn't see that in any of these appraisals. And I just perused them briefly, but.
Right, but I'm not sure that I have commonly seen that in appraisals, because what the appraiser is supposed to do is find the value of the property, find its market value. That's what the Iowa code tells us to do, find its value in exchange.
The law is that the value put on an owner is a value that can be used. I mean, if that's not there, it's irrelevant, so. Maybe we shouldn't go there.
Right, okay.
Let me ask, it seems like an issue coursing through both the income and the comparable sales approach is whether the building could likely be used as a single unit, or whether it would end up being a retail unit. And it seemed to me that almost everybody agreed that if it were retail, i.e. broken up, the value would be somewhat less than if it were, and I think that's true. Tell me what you think the state of the record is with respect to the prospects of a single purchaser coming in for the building.
All right. I think that the testimony overwhelmingly was that it was unlikely in the city of Des Moines that there would be a single user for this property.
What about the gobble up scenario that we just heard about?
Right. So I think, and I'd point out that one of the county's appraisers, Mr. Shaner, also in doing his income approach made an assumption that there would be more than one user of this property. And I think it's because of exactly what you just recognized, that it would lead to a higher value if you had more than one person, because it would make more potential users of the property. At trial, there was testimony from a broker and from the appraisers as well that it was unlikely that there would be a single user of the property that would come in to town and buy this building. Some of the examples that were given, for example, Wells Fargo purchasing Norwest, they didn't purchase it to bring in new employees. They purchased the business, not just the building here. So on cross-examination, Mr. Korpex was asked if he could identify any potential user of this property as a whole, and he said no, he could not. It's just a very large property for a market the size of Des Moines, and if you're looking at a comparable in Washington, D.C., like Mr. Corpex did in Arlington, Virginia, or somewhere in the suburbs, it's one thing. When you're looking at the city of Des Moines, there's not a lot of potential users. The Iowa Code specifically says the availability of potential purchasers of the property is one of the things that has to be considered in reaching its market value. And Judge McClellan specifically rejected Mr. Corpex's testimony that there would be someone standing on the sidelines ready to come in, by saying that was not a reasonable conclusion, having heard the testimony at trial in this matter. So I think that it was entirely appropriate for the court to consider who or whether there, I guess it's more like whether there are potential users, and how does that impact the value of the property. Whether you're deciding to use a sales comparable approach, which I think Judge McClellan did at trial, did look at the sales comparable approach, but he said he wasn't going to rely solely on the sales comparable approach, and that's when he turned to the others. The Court of Appeals, I think, looked at it a little differently and said there's no reasonable certainty that the sales comparable approach will get us where we need to go here, so we're going to look at the income approach, which of course is permitted under Iowa law if there isn't a reasonable certainty that you can come up with the value under the sales comparable approach. All right. So,
let me ask you this: is the time span, the 1 year period or less than a year, does that have any relevance in the evaluation?
The fact that it was a recently constructed building, I think that the impact that has is that it does cause someone to have, as Justice Mansfield said, a little bit of sticker shock, and you have to go a little deeper and determine whether under Iowa law, the fact that it's a relatively new building, what should the value be, even if we are looking at the cost approach, or what should the value be overall. But in looking at the obsolescence that was present there, their expert, Mr. Shaner, while he applied only a 20 or 30% obsolescence figure in his cost approach, recognized that other large buildings like this had a 50 to 70% obsolescence. So it's the issue of the amount of obsolescence that's present in a building of this size in this market that impacts the cost approach, and hence impacts a building that is admittedly relatively new and is a nice building. But
so are we to assume almost then that Wellmark knew that as soon as the building was done and they paid their $160 million that the building would be worth about half that?
Well, Mr. Crowley testified that he believed the property would have an assessed value significantly below that. I can't remember the exact number he used. There was a minimum assessment agreement in this case for $50 million, and I think he didn't think it was going to be significantly above that. The $78 million is quite a bit above that. But Wellmark did recognize that, and recognized that its market value under the law would be less than the amount spent to build the property.
Was there any testimony about this concept, that that's just the way these large corporations do business, that if they build their standalone flagship building, that they know that they're sinking in a lot more money than what it's going to be worth, and that's nevertheless reasonable? Mm-hmm.
I don't think there was a lot of testimony from the standpoint of corporate decision-making per se. It was more Wellmark's desire to bring all of its employees together in a single property, which they hadn't had before, and their desire to have a workspace that was open and was useful to them, but also useful to others as well. I mean, the testimony was that the assessor did not attribute any special use value to the property, and as a part of this case, Wellmark has not claimed that there was a mistake caused by including including matters that were special use and should have been excluded. And so many of the cases that the county cites that relate to whether percentage rent was properly included or other similar things like that aren't really applicable here, because what was done by the appraisers was to look at the full value of the property, and there was no argument that there was any special use value. So we would ask the court in this case to affirm the decision of the trial court, and consistent with the Court of Appeals, find that the $78 million value set by the trial court is the correct one for property tax purposes here. Thank you.
Thank you as well, counsel. Rebuttal?
The statute says that the property is supposed to be valued